Section 3, Drafting Errors and Contract Integrity. Contract law in today's market protecting contract integrity in real estate transactions. In the previous section, we explored mutual agreement, including acceptance, fraud, and the importance of honest negotiations in contract formation. Even when both parties genuinely intend to create a contract, problems can still arise if the agreement is influenced by improper conduct or if mistakes occur during the drafting process. Contract law recognizes that certain circumstances can undermine the integrity of an agreement and may allow a contract to be canceled or modified. Real estate transactions involve large financial commitments and complex documentation. Because of this complexity, drafting errors can occur more often than many professionals realize. When errors occur, courts examine whether the mistake affects the fundamental terms of the agreement and whether the parties intended to enter into the contract as written. Arizona licensees must exercise care when assisting clients with contracts because improper drafting or miscommunication can lead to disputes, litigation, and disciplinary action under ARS. Paragraph 32, 28153, which governs misconduct and violations by licensees. Maintaining the integrity of a contract begins with understanding the legal issues that may arise during contract formation. Undue influence in real estate transactions. Undue influence occurs when one party uses excessive persuasion or manipulation to overpower the decision-making ability of another party. Unlike duress, which involves threats or coercion, undue influence often involves subtle pressure applied by someone who holds a position of trust or authority. Undue influence is particularly relevant in real estate transactions involving elderly property owners, family members, caregivers, or trusted advisors. In these situations, one party may take advantage of the trust placed in them to convince the other party to enter into a transaction that may not be in their best interest. Courts evaluate undue influence by examining several factors, including whether a confidential relationship existed between the parties, whether the influenced party was vulnerable due to age or health, and whether the resulting agreement appears unfair or one-sided. For example, imagine an elderly homeowner who relies heavily on a caregiver for daily assistance. If the caregiver persuades the homeowner to sell the property significantly below market value while discouraging the homeowner from seeking outside advice, the court may determine that the agreement was the result of undue influence. In such situations, the contract may be considered voidable, allowing the injured party to cancel the agreement. Real estate professionals must be alert to situations where clients appear pressured or confused about a transaction. Ethical practice requires that licensees ensure clients are making decisions voluntarily and with full understanding of the transaction. Contract mistakes. Unilateral versus mutual mistakes. Mistakes can occur during contract negotiations and drafting. Contract law recognizes two primary types of mistakes: unilateral mistakes and mutual mistakes. Understanding the difference between these two concepts helps determine whether a contract can be enforced or corrected. A unilateral mistake occurs when only one party is mistaken about a material aspect of the contract. For example, a buyer may accidentally enter an offer price of $550,000 instead of $505,000 due to a typographical error. If the seller accepts the offer before the mistake is discovered, the buyer may attempt to argue that the contract should be rescinded. Courts generally enforce contracts involving unilateral mistakes unless the other party knew or should have known about the mistake. A mutual mistake, on the other hand, occurs when both parties share the same incorrect understanding of a material fact. For example, both the buyer and seller may believe that a property is connected to municipal water when in fact the property relies on a private well. Because both parties relied on incorrect information, the contract may be subject to rescission or modification. Arizona courts often allow contracts to be canceled when a mutual mistake affects a material element of the agreement, meaning the mistake significantly impacts the value or purpose of the contract. Importance of written documentation. Real estate contracts must generally be in writing in order to be enforceable. This requirement comes from the Statute of Frauds, a long-standing legal doctrine that requires certain types of contracts, including contracts for the sale of real property, to be documented in writing and signed by the parties involved. In Arizona, this requirement is codified in ARS, paragraph 44101, which specifies that agreements for the sale of real property must be in writing to be enforceable. The purpose of the Statute of Frauds is to prevent misunderstandings and fraudulent claims by ensuring that the terms of important agreements are clearly documented. Written contracts provide evidence of the parties' intentions and allow courts to determine what obligations were agreed upon. For real estate professionals, written documentation is essential for protecting both the client and the licensee. Written records establish a clear timeline of the transaction and provide proof of the terms agreed upon by the parties. In modern real estate practice, these records often include electronic signatures, digital transaction files, email communications, and contract addenda. Arizona administrative rules also require brokers to maintain transaction records. Under ARS Paragraph 32-2151.01, brokers must maintain complete records of real estate transactions, including contracts, receipts, and related documents. Proper record keeping helps ensure compliance with regulatory requirements and protects the parties involved in the transaction. Case study: contract drafting error and transaction consequences. Consider the following scenario that demonstrates how drafting errors can affect a real estate transaction. A buyer submits an offer to purchase a property for $420,000, but during the preparation of the contract, an agent accidentally enters $240,000 as the purchase price. The seller signs the contract without noticing the mistake, believing that the document reflects the agreed-upon price. When the escrow officer reviews the contract during the transaction process, the error is discovered. The buyer insists that the signed contract clearly states $240,000, while the seller argues that the mistake does not reflect the actual agreement between the parties. In situations like this, courts often examine whether a mutual mistake occurred and whether the written contract accurately reflects the intent of the parties. If both parties intended the purchase price to be $420,000, the court may allow the contract to be corrected through a legal remedy known as reformation, which modifies the written document to reflect the true agreement. However, situations like this can still lead to delays, disputes, and potential litigation. This example demonstrates why careful drafting, proofreading, and review of contract terms are critical steps in every real estate transaction. Online discussion. 1. Question: why is undue influence particularly concerning in real estate transactions involving elderly property owners? Answer: elderly property owners may rely heavily on trusted individuals such as caregivers or family members. If those individuals use that trust to pressure the homeowner into making a transaction that is not in their best interest, the agreement may be considered the result of undue influence and may be voidable. 2. Question: what is the difference between a unilateral mistake and a mutual mistake in a contract? Answer: a unilateral mistake occurs when only one party is mistaken about an important contract term. A mutual mistake occurs when both parties share the same incorrect belief about a material fact related to the contract. Mutual mistakes are more likely to allow the contract to be rescinded or modified. 3. Question: why is written documentation so important in real estate transactions? Answer: written documentation ensures that the terms of the agreement are clear and enforceable. It also provides evidence of the parties' intentions and helps prevent disputes about what was agreed upon. Written records are required under the Statute of Frauds and by Arizona record-keeping laws.